Okay, I was reading about due diligence requirements for private banking. I'm on page 907 of the new text, and I was defining private banking and got to see the fact that a bank terms its products or services a private banking account does not bring it under the provisions of the regulations. The requirements of having at least $1 million must be met for it to be considered a private banking account. Minimum requirements A through D. The bank must ascertain the identity of all nominal and beneficial owners. And B, the bank must ascertain whether any person identified as a nominal or beneficial owner is a senior foreign political figure. C, bank must ascertain the source of funds deposited into a private banking account. D, the bank must review account activity as necessary to ensure that activity is consistent with the information obtained about the client's source of funds and with the stated purpose and expected use of the account to guard against money laundering and to report any known or suspected money laundering or suspicious activity. 4. Requirements for senior foreign political figures. A. If an owner of the private banking account is a senior foreign political figure, the due diligence must include enhanced scrutiny of the account that is reasonably designed to detect and report transactions that may involve the proceeds of foreign corruption. B. The term foreign corruption refers to Roman numeral 1, assets or property acquired by, through, or on behalf of a senior foreign political figure by means of misappropriation, theft, or embezzlement of public funds, the unlawful conversion of property of a foreign government, or acts of bribery or extortion. Any other property into which assets deemed to have been acquired through foreign corruption have been transformed or converted. The term senior foreign political figure refers to any of the following persons: a current or former senior official in any of the executive branch, legislative branch, judiciary, military, administrative agency of a foreign government. Furthermore, a current or former senior official of a major foreign political party or a senior executive of a foreign government-owned commercial enterprise. Roman numeral 2. Senior foreign political figure refers to a corporation, business, or other entity owned or formed for the benefit of any of those persons, or an immediate family member of any of those persons, or a person who is widely and publicly known to be a close associate of any of those persons. Roman numeral 9, Section 9, Information Sharing Procedures to Deter Money Laundering and Terrorist Activity, is going to talk about our 314A requests, information requests, and our 314B information requests. As per the USA Patriot Act, this provision facilitates information sharing among federal government agencies and financial institutions. Information requests referred to as 314A, 314As, a federal, state, local, or certain foreign law enforcement agency investigating terrorist activity or money laundering may request that FinCEN solicit information from a financial institution or a group of financial institutions. A. Written certification. The agency must certify in writing that it is seeking information on an individual or entity engaged in or based on credible evidence reasonably suspected to be engaged in terrorist activity or money laundering. B. Specific identifiers. The certification must include specific identifiers that together permit a financial institution to differentiate between common or similar names. Specific identifiers include information such as date of birth, address, or social security number. Contact person. The certification must identify one person at the agency who can be contacted with questions relating to the request. 2. Obligations of financial institutions, I suppose, receiving information requests. Must perform a record search. On request of FinCEN, a financial institution must expeditiously search its records to determine whether it maintains or has maintained any account for or has engaged in any transaction with each individual entity or organization named in the FinCEN request. A financial institution will only be required to search its records for any current account for a named suspect, or any account maintained for a named suspect during the preceding 12 months, or any transaction conducted by or on behalf of a named suspect. For purposes of this regulation, the term transaction refers specifically to a deposit, withdrawal, transfer between accounts, exchange of currency, loan, extension of credit, purchase or sale of any stock, bond, certificate of deposit, or other monetary instrument. That means check your monetary instruments log. Report to FinCEN requirement on financial institutions identifying an account or transaction connected with any individual or entity named in a request from FinCEN. It must report to FinCEN the following information: 1 through 3. 1. Name of each such individual or entity. 2. Number of each such account or date and type of each such transaction. And 3. Any social security number, TIN, passport number, date of birth, address, or similar identifying information. D. Designation of contact person. On receiving an information request, financial institution must designate one person to be the contact person regarding the request and must update the designation whenever changes are made. The use of information requirement. A financial institution shall not use information provided by FinCEN for any other purpose other than reporting to FinCEN, determining whether to establish or maintain an account, or 3. Assisting the financial institution to comply with any requirement of this regulation. Requirement for disclosure of information. A financial institution may not disclose to any person or entity other than FinCEN or the federal law enforcement agency on whose behalf FinCEN is requesting the information the fact that FinCEN requested the information. So it can't disclose that. Security of request. Financial institutions must maintain adequate procedures to protect the security and confidentiality of FinCEN information requests. No further obligations. No other action is required of a financial institution with respect to any account or transaction with any individual or entity named in a request from FinCEN. And lastly, in the requirements section, financial institutions should develop and implement comprehensive policies and procedures for responding to 314A requests. B. Voluntary information sharing among financial institutions. 314B request. The coverage is A. Financial institutions that are required to establish and maintain anti-money laundering programs. B. Association of financial institutions, a group or organization, the membership of which is entirely composed of financial institutions. 2. Provisions of voluntary information sharing. All right, I'm listing things right now. Voluntary information sharing among financial institutions. It covers financial institutions and associations of financial institutions, to put simply. Okay, the provisions is voluntary information sharing under the safe harbor, transmit, receive, or otherwise share information with other financial institutions or associations of financial institutions regarding individuals, entities, organizations, and countries for purposes of identifying and reporting activities that the financial institution or association suspects involve possible terrorist activity or money laundering. The notice requirement, verification requirement, use of information, information security, and safe harbor, SAR filing, are discussed before we go into CIP program requirements. So the notice requirement 1 and 2. 1. Financial institutions or associates that intend to share information must provide a notice to FinCEN, and notices will be effective for 1 year. C. Verification requirement. Before sharing information, a financial institution or association must take reasonable steps to verify the other financial institution or association with which it intends to share financial information has submitted the required notice to FinCEN. Use of information. Information received in this regulation may be used only for identifying and reporting on money laundering and terrorist activity, 2. Determining whether to establish or maintain an account or to engage in a transaction, and 3. Assist the financial institution in complying with any requirement of this regulation. E. Information security. Each financial institution or association that engages in voluntary information sharing must maintain adequate procedures to protect the security and confidentiality of the information. And more about the safe harbor. Each financial institution or association that shares information under this section will be protected from liability to any person for such sharing. And SAR filing, lastly, if as a result of voluntary information sharing under this section, a financial institution knows or has reason to know that an individual or entity is engaging in terrorist activity or money laundering, the financial institution must file a SAR. The CIP requirements coverage. In this context, the term account refers to a formal banking relationship established to provide or engage in services. Examples include deposit accounts, asset accounts, credit accounts, including extensions of credit, cash management accounts, trust accounts, safe deposit boxes, and safekeeping services. The coverage under the CIP requirements does not include the provision of products or services when a formal banking relationship is not established. Examples of such products or services include check cashing, wire transfer services, and sales of money orders to non-consumers. Coverage does not include accounts acquired through mergers or acquisitions, nor does it include accounts opened for the purpose of participating in employee benefit plans, and accounts held by banks' foreign subsidiaries are also not covered. Customers covered by CIP requirements are persons who open a new account for himself or herself, or for a person lacking legal capacity, or for an entity that is not a legal person. Coverage does not include existing customers who open new accounts, provided the bank has a reasonable belief that it knows the customer's true identity. Further, coverage does not include a person holding a power of attorney for a competent person. In this case, the customer is the named owner of the account, and the person holding the power of attorney is merely an agent. Last, coverage includes new cosigners added to existing accounts and borrowers who assume existing loans. The CIP requirements include, in general, a bank having a written CIP customer identification program that is appropriate for the size and type of business. If a bank is required to have an anti-money laundering program, then the CIP must be part of this program. Minimum CIP requirements are as follows. Risk-based procedures in place for verifying the identity of each customer. The procedures including that which must be done to form a reasonable belief that the bank employee knows the identity of each customer, and the perception of relevant risks which could arise from various types of accounts, various methods used to open accounts, various methods of identification, and the bank size, location, and customer base. Specifically, the CIP program procedures should identify what information should be obtained to verify customers' identity. At a minimum, this includes name, date of birth for an individual, address, which shall be for an individual a residential or business street address. Rural routes are acceptable for an individual without a residential or business street address, either an Army post office box, a fleet post office box, or a residential or business street address of the individual's next of kin or other contact individual, and C for a business, either street address or physical location. The identification number for a U.S. person is a TIN. For a non-U.S. person, it can be a TIN, passport number, and country of residence, alien identification card, and number and country of issuance of another government-issued document that shows nationality or residence and bears a photograph or similar safeguard. Customers who have applied for a TIN, as long as the bank has procedures for customers who have applied for a TIN but have not yet received it, the account can be opened. The procedures must confirm that the application was applied for prior to opening the account and have a method for obtaining the ID number within a reasonable period of time. For credit card accounts, customers applying for a credit card account, the bank can obtain the identifying information from a third-party source. Verification requirements. A CIP must contain procedures for verifying the identity of customers within a reasonable period of time after the account is open. Procedures must describe when documentary methods, non-documentary methods, or a combination of both must be used. And if the bank is verifying identity through documents, the CIP must set forth the documents that the bank will use. Acceptable documents may include the following for an individual: an unexpired government-issued identification bearing photograph or similar safeguards, such as a driver's license or passport showing nationality or residence. For a non-individual, such as corporation or partnership, documents that show the existence of the entity, such as articles of incorporation, business licenses, and so forth. And D, if the bank is verifying identity using non-documentary methods, the CIP must state the types of non-documentary methods that will be used, and this is where I picked up in another recording.